ಹಿಯರಿಂಗ್ ಆಯ್ತೇನು ಮೇಡಮ್? ಇಲ್ಲಲ್ಲ.
ಟಾಪ್ ಆಫ್ ದಿ ಬೇ ಗ್ರೂಪ್ 20ನೇ ತಾರೀಕು.
ಓಕೆ.
ಸರ್ 2:30 ಕರೀತಾರಲ್ಲ? ನಿಮ್ದು ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟ್ರ್ ಬಂದಿಲ್ಲ ಮೇಡಮ್ ನಿಮ್ಮ ಪಾರ್ಟಿ? ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಅವ್ರು ಸುಮ್ಮನೆ ನಮ್ಗೆ ಯಾವಾಗ ಟೈಮ್ ತೊಗೋತಾರೆ 10:30 ಬಂದು ಯಾರು ಹೇಳಕ್ಕೆ ಬಂದು ಲೇಡಿ ತೊಗೊಂಡ್ಬಂದ್ಬಿಡ್ತಾರೆ. ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ, ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇರೋದು ಇಲ್ಲ.
ನೋ ಫಸ್ಟ್ ಪಾಸೋರು.
ಹಲೋ, ಇಲ್ಲ ಮೇಡಮ್ ಬಂದು ಹೇಳ್ತೀನಿ. ಅಲ್ಲಿ ನಿಮ್ಮ ಹತ್ರ ಐತೆ ನೋಡಿರಿ ಮೇಡಮ್, ನಂಬರ್ ಹಚ್ಚಿಬಿಟ್ರಿ. ಫೈನಲ್ ಬಂದು ಕಳಿಸ್ತೀನಿ ಮೇಡಮ್. ಬಂದಿಲ್ಲ ಅವ್ರ
ಫೈನಲ್ ಇಯರಿಂಗ್ ತಗೊಳ್ತಾರೆ ಮ್ಯಾಮ್.
ಸರ್ ಇವತ್ತು ನಿಮ್ಗೆ ಪ್ರೆಸೆಂಟ್ ಇರಕ್ಕೆ ಹೇಳಿದ್ರು, ಸಾಹೇಬ ಬರತ್ಲೆ ರೆಡಿ ಅಂತ ಹೇಳ್ಬಿಡಿ.
ತಗೊಳ್ತಾರಲ್ಲ
ನಾಳೆ ನೀವು ಮಾಡಿ
ಡಿಕ್ಟೇಷನ್ ಆರ್ಡರ್ ಅದು ಏನೋ ಅದಂತಲ್ಲ.
ಆಗತ್ಲೆ ನಿಮ್ದೆ ನೀವೆಲ್ಲ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿರ, ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಹಾಕಿರಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ.
ಬರತ್ಲೆ ಒಂದು ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ಮೇಡಮ್ ಎಲ್ಲ ಮ್ಯಾಟ್ರ್ ಅರ್ಜೆಂಟ್ ಮೇಡಮ್. Kind of 44.
ಅದು ಡಿಕ್ಟೇಷನ್ ಆದ್ಮೇಲೆ ತಗೊಳ್ತೀನಿ. You wait.
My lord, serial number 56, my lord. Final hearing in murder case, my lord. Okay, today.
You want time?
I am 56, my lord. I am ready for all. Tomorrow. Monday, my lord, at this time. Monday, my lord. Monday.
But you must wait.
Monday,
You must come and wait.
definitely, my lord. Oblige.
We will have our own work. But you must wait because after Monday we may not take up fresh matters. These matters require some detailed hearing. We want to wind up.
Yes.
So if since you are on 10 years, we'll take it up provided you fully cooperate.
Definitely,
Monday.
I will be there.
You must wait. Even if
Oblige.
you are busy with some matter, you wait. Come correctly by 2:30 and you wait.
Great. Great.
And dictation.
Number 15.
We'll take up past war matters after this. Huh? You can finish some other work and come. So, but dictation ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ಗ್ಯಾಪ್ ಆಗುತ್ತೆ. Let the dictation finish. ಒಂದು ಅರ್ಧ ಮುಕ್ಕಾಲು ಗಂಟೆ ಆದ್ಮೇಲೆ ಬನ್ನಿ.
Please.
With regard to the serial number 22, my lord, it will take within the 5 minutes time, my lord.
ಅಲ್ಲ, ಆಯ್ತು.
Pass over matter, my lord. Serial number
Dictation ಆದ್ಮೇಲೆ after
much. Please, my lord.
After 3:15 we'll take up the rest of the matter.
ಅದಲ್ಲ ಅದು ಅದ್ರದ್ದು ಬರ್ತದೆ, ರೆಕಾರ್ಡ್ ಆಗುತ್ತಾ? ಹಾಕ್ಬೇಕು ಇದನ್ನು. ಕೂತ್ಕೊಳ್ಳಿ. ಸ್ಟೇಟ್ the state has preferred this appeal against the judgment dated 1/2/2014 1/12/2014 in SC number 5 of 2014 passed by the Court of Additional District and Session Judge at Bidar, hereinafter referred as a Session Judge, learned Session Judge, whereby the learned Session Judge has acquitted the respondents/accused for the offence punishable under section 498A and 304B, read with section 34 of IPC and section 3 and 4 of Dowry Prohibition Act. The abridged facts of the case are as follows. the respondent accused in the instant case are the husband, accused number 1 bracket alli, and mother-in-law bracket alli, accused number 2 of the deceased Anita, full stop. The marriage between the accused number 1 and deceased was solemnized on 28/6/2012 at Chidri village, full stop. At the wedding, a dowry of rupees 45,000, 10 grams of gold and a few domestic household articles were given to the accused, full stop. Following the wedding, the accused number 1 and the deceased were residing along with the accused number 2, full stop. Several months into the marriage, the accused started to harass the deceased both physically and mentally, demanding rupees 1 lakh and a bed as further dowry, a cot as a further dowry, full stop. A wooden cot as a further dowry, full stop. The deceased divulged the same to PW1 on 9/5/2013.
Yes.
PW1, who is the brother of deceased, on 9/5/2013. She once again called PW1 and informed about the harassment meted out by the accused regarding the demand of additional dowry and requested him to take care to her maternal home.
Yes.
Full stop. Subsequently, on 12/5/2013, PW23 called PW1 and informed that
Yes.
that his sister, that is the deceased Anita, hanged herself to the iron rod in the room of the matrimonial home, full stop, and she was found dead.
Yes.
Full stop. Immediately, PW1 along with these relatives rushed to the house of the accused and witnessed the corpus of the deceased being suspended from the iron rod sheet, full stop. Thereafter, PW1 lodged a complaint before the Gandhi Ganj
Police
police
station.
station, Bidar, against the accused number 1 and 2 as per exhibit P1, full stop. Next, on the strength of exhibit P1, on the strength of the said complaint, the complainant police registered a case against the accused in crime number
85 of
2013, dated at 12/5/2013
at 10:30.
2013 for the offence punishable under section
498A,
498A
not 6.
and 498A, 306, 304B, read with 34 of IPC, and
3 and 4
offence
of
under section 3 and 4 of Dowry Prohibition Act, full stop. Thereafter, PW27 conducted the further investigation by drawing the spot mahazar, and after recording the statements of the relevant witnesses and on obtaining necessary documents from the concerned authorities, he laid the charge sheet against the accused before the committal court. After committal of the case before the session courts, the learned session judge framed the charges against the accused, charges for the aforementioned offences, and the same was read over to the accused, full stop. However, The accused denied the charges and claimed to be tried. Next, in order to prove the charges leveled against the accused, the prosecution collectively examined 29 witnesses as PW 1 to PW 29, marked 15 documents as
Exhibit P1
Exhibit
to
P1 to P15,
yes,
and identified 3 material objects, MO
1 to 3.
as MO 1 to
3.
1 to 3. 1 to 3. Next, following the assessment of oral and documentary evidence placed before the session court, the learned session judge acquitted the appellants acquitted the respondents accused for the charges leveled against them. Full stop. The said the judgment is challenged in this appeal by the state.
Yes.
We have heard learned additional SPP, she is Patil for the complainant state, and learned counsel Sri
Avinash
Upalankar for respondents accused, and also perused the records made available before us. The primary contention of the learned additional SPP that the session court has grossly erred in acquitting the accused respondents despite the prosecution placing preponderance of evidence before the session court. Full stop. He contended that the prosecution has proved the demand and acceptance of the acceptance dowry amount by the accused number 1 and 2, and the cruelty meted out by them for additional dowry. Full stop. Owing such cruelty, the victim committed suicide in her matrimonial home. Full stop. The evidence of PW 1, 7 and 25, that is the brother, uncle and relative of the deceased. How the relative of the deceased, respectively, the deceased respectively, have deceased have categorically deposed that 3 days prior to the incident, the deceased called them and informed that the accused subjected her to cruelty by demanding additional dowry. Full stop. Nevertheless, the testimony of PW 14 and PW 15, the villagers, clearly corroborates with the evidence of PW 1, 7 and 25.
From PW 8 to 15, all your support.
25. Full stop. These witnesses have stated that the deceased informed them about the cruelty meted out by the accused number 1 and 2 to her soon before her death. Death. In such circumstance, there is no reason to discard the evidence of all these witnesses. Full stop. The session judge, without appreciating the evidence of material witness, passed the impugned judgment which suffers from perversity and illegality. Full stop. He would also contend that the evidence of PW 8 to 14,
15, sir.
PW 8 to 15, 8 to 15, the villagers and other relatives of the accused also clearly disclosed that, also clearly establishes that the accused number 1 and 2, 1 and 2 harassed the deceased for additional dowry, and due to the same she committed suicide in the matrimonial home. Full stop. Lastly, it would submitted that though this appeal is against acquittal, nevertheless the view taken by the session judge is legally not plausible view. Plausible. Full stop. Hence, miscarriage of justice has been caused to the victim, and accordingly he prays to set aside the impugned judgment and by allowing the appeal, and also prays to convict the accused for the charges leveled against them. Full stop. Next one. Per contra, the learned counsel for the respondent accused submitted that the learned session judge, on duly appreciating the entire evidence on record, passed a well-reasoned judgment which does not call for any interference at the hands of this court. Full stop. He further contend that since this appeal is against acquittal, comma, as per the settled principle of law, comma, if a plausible view is taken by the session court, the appellate court must be slow in interfering in the acquittal order. Full stop. He further contend that the material witness PW 1, 7 and 25 are the family members, and that they are the hearsay witness. As such, much credence cannot be attached to their evidence. Full stop. According to him, the prosecution has failed to produce the call detail register, bracketally CDR, to prove the aspect that the deceased called PW 1, 7, 25, PW 1, 7 and 25, 25
On 9/5.
on 9
5
5 2013.
Yes.
That is 3 days prior to the
incident.
prior to the incident. Full stop. Prior to the incident. In such circumstance, comma, the session judge has rightly acquitted the accused for the charges leveled against them. Full stop. He would also contend that the evidence of PW 8 to 15
Yes.
was the neighbor, or 8 to 13, comma, who are the neighbors have stated that they came to know through somebody about the harassment meted out by the accused to the deceased. Full stop. However, in their cross-examination, they have categorically admitted that the PW1 has not stated about the harassment meted out by the deceased, by the accused to the deceased. Full stop. In such circumstance, comma, the session judge has elaborately considered the evidence on record and acquitted the accused. Full stop. Accordingly, he prays to dismiss the appeal. To buttress his argument, he relied on the judgment of the Honorable Apex Court in the case of Charan Singh alias Charanjit Singh versus State of Uttarakhand in Criminal Appeal number 447 of 2012. Full stop. Having heard the learned additional SPP and learned counsel for the respondent accused, and upon comprehensive perusal of the evidence on record, comma, the points that surface for our consideration are: 1, whether the judgment under this appeal suffers from perversity and illegality. 2, whether the learned session judge is justified in acquitting the accused / appellants for the offence charged. Next, in the instant case, comma, albeit the prosecution examined 29 witnesses to prove the charges leveled against the accused, it is sufficient to dwell into the evidence of the material witness. Full stop. In the full stop. In the case on hand, comma, the deceased Anita's demise is owing to suicide, and her mode of death is not seriously disputed by the accused. Full stop. Nevertheless, to prove the same, the prosecution has examined PW 22, the medical officer.
Yes. Who
conducted the autopsy.
Yes.
Conducted the autopsy on the corpus of the deceased and issued post-mortem report as per post-mortem report exhibit P11. Exhibit P11, which depicts that the death of the deceased is due to asphyxia on account of hanging. It is an admitted case of the complainant and other witnesses that the deceased committed suicide, suspending herself by the roof at the accused's residence. Full stop. in order to connect the next parallel, in order to connect the accused with her death, comma, the prosecution predominantly relied the evidence of PW 1, 7 and 25, that is the complainant, comma, uncle and relative of the deceased respectively.
Yes.
Full stop. They have categorically deposed that 2 months into their marriage, 2 months into their marriage, into the marriage of the deceased and accused,
Yes.
comma, the deceased called them and informed them regarding the additional dowry demand by the accused.
Yes.
By the accused. Further, PW 1 and 7 also received a call from the deceased 3 days prior to the incident, that is on 9/5/2013, informing them that the accused harassed her both physically and mentally by threatening her with the dire consequence for failure on her part to pay a further dowry of rupees 50,000. 50,000. Full stop. Later on 12/5/2013,
Yes.
the deceased committed suicide in her matrimonial home. Full stop. According to PW 25, the deceased called her 15 days prior to her demise and informed her that the accused were demanding additional dowry. Full stop. The evidence of these witnesses was supported by PW 8 and 9, who were present during the marriage talks.
Yes.
Alva?
Yes.
Present during the marriage talks.
Even PW 8 to 13.
8 and 9 present during the marriage talk. Avaribralva. Full stop.
Marriage talks.
They have categorically deposed that during the wedding, the dowry of rupees 45,000, 1 tola gold and a few domestic household articles were demanded by accused number 1 and 2. Full stop. They also stated that after 2 months into her wedding, they learnt about the deceased being ill-treated by the accused, which compelled her to commit suicide. Full stop. Further, PW 10 to 15, the residents of Chidri village,
No,
village,
no.
where the deceased, Chidri Belappa, adu onde alva?
No, sir. Bemalkheda is a deceased parental house.
PW 10 to
10 to 15 minutes. PW 10 to 15 minutes.
all are Belappa, na?
Bemalkheda.
The resident of where the accused and deceased were staying.
No minutes. They are residents of parental house of the
Parental
deceased.
house also. Further, PW 10 to 15, the residents of Belappa, residents of
Bemalkheda.
Bemalakeda, that is the parental house.
Parental
That is the parental house of the deceased.
Yes.
Have deposed regarding the demand of additional dowry by the accused number 1 and 2, and also the ill treatment meted out by them
Yes.
to the deceased. Full stop. Among these witness, PW 14 and 15 are the neighbors.
Neighbors.
Are the neighbors, neighbors have stated that soon before the demise of deceased, she visited the house. She visited their house and informed them about the harassment meted out by the accused number 1 and 2, demanding additional dowry.
Yes.
Demanding additional dowry. Full stop. Though demanding additional dowry. Full stop. Though the defense cross-examined this witness at length, their testimony remained unshaken. Full stop. Further, the evidence of all these witnesses clearly corroborates to the contents of
PW.
Exhibit P1, that is Exhibit P1 complaint lodged by
PW1. Yes.
PW1, full stop. On perusal of the complaint, on full stop, on perusal of the complaint averments, comma, PW1 has on perusal of the complaint averments lodged at the earliest point of time, comma, PW1 has stated that the accused number 1 and 2 were are ill-treating the deceased, ill-treating his sister, the deceased Anita, to bring additional dowry, And on 9/5/2013, comma, the deceased Anita had informed PW1, that the accused were harassing, harassing her and requested him to take her to the matrimonial home.
Yes.
Matrimonial home. Full stop. After 3 days, thereafter 3 days, comma, she committed suicide.
That
She
is on
committed
the-
suicide in the matrimonial home.
That
Full
is on
stop.
12/5/2013.
That is
12/5/2013.
12/5/2013.
Yes, ma'am. 13. ma'am.
2013, full stop. Next part. To prove the offence punishable under section 304B of IPC, comma, the prosecution has to establish the following aspects. Number 1, the death of the deceased must have been caused by either burns or bodily injuries, or her death must have occurred otherwise than under normal circumstance. Madam IPC, good. IPC. Other than the normal circumstance. Number 2, such death must have occurred within 7 years, of her marriage.
Yes.
Number 3, soon before her death, she must have been subjected to cruelty or harassment by her husband or any relative of her husband, and such cruelty or harassment must be in connection with the demand for dowry. Full stop. On careful perusal of the evidence of the above witnesses, comma, and Exhibit P1 complaint, the prosecution has established that the death of deceased Anita has occurred otherwise than under normal circumstance, comma, comma, indeed it has occurred within 7 years of her
Yes.
marriage.
Yes.
Full stop. To prove the primary contention that the accused number 1 and 2, primary contention of the learned SPP, that the accused number 1 and 2 subjected the deceased to cruelty soon before her death, comma, the prosecution has placed cogent evidence of PW1, comma, 7, PW1, 7 to 15 and 25. 25.
Yes.
Regarding the demand made by the accused for dowry at the time of marriage, and the additional dowry demanded by him, demanded by both the accused, number of accused, subsequently, again 3 days prior to her death. 3 days prior to her death. Full stop. According to PW1 and PW7, according to PW1 and 7, comma, the deceased informed them about the demand of additional dowry and the harassment by the accused on 9/5/2013. It is a specific evidence of these witness that accused threatened the deceased with the life threats, failure to fulfill additional dowry.
Yes, yes.
Fulfill additional dowry demands of rupees 50,000, 50,000. Full stop. This evidence prima facie established that soon before her death, comma, she was subjected to cruelty at the hands of accused. Full stop. Accused. Full stop.
Even my lords, even PW 1, 7 and 25 also.
As 25 could actually. PW 1, 7 and 25.
Yes,
25. Full stop. In such circumstance, comma, the Honorable Apex Court in the case of Bansilal versus State of Haryana reported in 2011, volume 11, SCC 359 held in paragraph 17, paragraph 17 to 20, 17 to 20 as under, 17 to 20 as under. 17 to 20 as under. Full stop. The full stop. On the applying the above findings of the Honorable Apex Court in the instant case, comma, as discussed supra, the evidence of material witness categorically established that both the accused subjected the deceased to cruelty within 2 months into their matrimonial alliance.
yes.
And the said harassment compelled her to commit suicide. In such circumstance, comma, such circumstance, comma, the presumption under section 113 of 113B of Indian Evidence Act, applies. Evidence Act, comma, Evidence Act has to be applied, and the court can presume that except the harassment meted out by the accused, comma, no other circumstance compelled the deceased to commit suicide in the matrimonial home. Full stop. Matrimonial home. It is the full stop. For the learned counsel for the respondent accused has argued that the evidence of comma PW 1, 7, 25, PW 1, 7 and 25 cannot be relied for the reason that they are the partition witnesses. Full stop. Partition witnesses. Full stop. On careful perusal of the evidence of these material witnesses, comma, we find their evidence are credible and trustworthy. There is no reason to discard their evidence only for the mere reason that they are relative / partition witnesses. The Honorable Apex Court in the case of Revanna Sahib Gowda alias Revanna Sahib, comma, was the State of Karnataka reported in 2023, volume 5, SCC 391 held in paragraph number 17 as under. Full stop. 17 as under. Short is the it is clear that it is the quality and not the quantity of the witness that matters. Full stop. Further, in paragraph number 25 of the said judgment, the above judgment, it is stated that a witness being a close relative is not a ground enough to reject his / her testimony. Full stop. Mechanical rejection of an even partition or interested witness may lead to failure of justice. Full stop. The principle of failure of justice. The principle of false in omnibus is not the one of the general application. Full stop. Further, it is argued by the learned counsel for the respondent accused that there are minor contradictions. There are minor there are contradictions. There are contradictions in the evidence of PW 1, 7 to 15 and 25. Full stop. As discussed supra, those minor contradictions do not go to the root of the prosecution case. Full stop. The Honorable Apex Court in the case of Mallikarjun and others was the state of Karnataka, reported in 2019, volume 8 SCC 359, has held that the minor contradictions in the evidence of material witness itself is not a ground to discard their testimony. Full stop. Further, the Honorable Apex Court held that while appreciating the evidence of a witness, the approach must be to assess whether the evidence of a witness read as a whole appears to be truthful. Full stop. Once the impression is formed, it is necessary for the court to evaluate the evidence and the alleged discrepancies, and then, to find out whether it is against the general tenor of the prosecution case. If the evidence of witness is found to be credible and trustworthy, minor discrepancies which do not affect the core of the prosecution case, cannot be made a ground to doubt the trustworthiness of the witness. Full stop. The learned counsel for the respondent accused contended that since this is an appeal against acquittal, unless perversity is proved in the impugned judgment, the appellate court must be shall not interfere with the impugned judgment. Full stop. We are well acquainted with the guidelines issued by the Honorable Apex Court while interfering in the acquittal judgment. However, the appreciation of the evidence is the core element in a criminal trial, and such appreciation of evidence must be in a comprehensive manner, inclusive of all oral and documentary evidence, Full stop. The partial or selective appreciation of the evidence would cause utter miscarriage of justice. Full stop. In the instant case, the learned session judge, while appreciating the evidence of material witness, failed to consider the cogent evidence of material witness, that is PW 1, 7 to 15 and 25.
Yes.
25 placed by the prosecution. Full stop. All these witnesses have categorically deposed regarding the cruelty unleashed by the accused soon before the death of the deceased. Full stop. On account of dowry demand by the accused. Nevertheless, the accused failed to explain under what circumstance and what compelled the deceased to commit suicide in the matrimonial home within 1 year from the date of her marriage. Full stop. The accused remained silent in his 313 statement, and also did not venture to lead any evidence to substantiate the reason for the suicidal death of the deceased.
Yes.
Full stop. In such circumstance, the accused is duty bound to explain the said circumstance as per the provisions of section 106 of Indian Evidence Act.
Yes.
Full stop. Since the incident occurred in the house, occurred at accused residence, accused residence, full stop. Failing which the court can draw an inference against the accused under the provisions of section 113 of 113B of Indian Evidence Act, full stop. The learned session judge has failed to consider this aspect of the matter, full stop. Per contra, the learned session judge, by considering the evidence of PW 17 and 24,
Yes.
17 and 24, both turned hostile to the prosecution case. Both turned hostile to
16 also, sir.
PW 16, 17 and 24. All these witnesses have turned hostile to the
16 and
prosecution.
17 are, they belongs to Chidri village, the
P-
accused village.
PW 16, 17 and 24.
24 is the elder brother of the accused.
16 and 17, huh?
Yes, sir.
Sorry, 16 and 17. 16 and 17,
Yes.
so bracketally both turned hostile. In the session judge, by considering the evidence of PW 16 and 17, bracketally both turned hostile, acquitted the accused for the charges leveled against them, full stop. This appreciation of the evidence can be implied as a selective appreciation by the learned session judge, full stop. The Honorable Apex Court in Category of Judgments, held that one of the essential ingredients of dowry death under section 113 of Indian Evidence Act, is that the accused must subject the woman to cruelty in connection with the demand for dowry soon before her demise, full stop. Further, these essential elements must be proved by the prosecution beyond reasonable doubt, full stop. Against the backdrop, the court presumes that the accused committed the offense of dowry death under section 113 or 113B of Indian Evidence Act, 113B of Indian Evidence Act. One minute. 113 of B of Indian Evidence Act, full stop. At the cost of repetition, on perusal of the evidence of PW 17 to 15 and 25, 1 to 25, the same depicts that both the accused subjected the deceased to cruelty by demanding additional dowry of rupees 50,000. This evidence of full stop. The evidence of PW1, the brother of the deceased,
Yes.
categorically corroborates with the evidence of PW7 and 25, the family members. So also the neighbors PW14 and 15.
Yes.
14 and 15, full stop. Albeit PW8 and 13 are hearsay witness.
Yes.
That hearsay
Yes.
witness, they have stated that since they are the resident of same village, they learnt about the harassment meted out by the accused for additional dowry, and PW through PW1 and PW7, through PW1 and 7, full stop. The PW1 and 7, full stop. The PW1 and 7 further deposed that though the deceased called them and informed about the severe harassment being endured by her, and her repeated requests to return to her maternal home.
Yes.
Maternal home, comma, was stalled by PW1 for the reason that he was busy in harvesting, and he was unable to arrange the fund, demanded by the accused. As such, he informed her that he would visit the house for about next 4 to 5 days. Full stop. Unfortunately, in the meantime, she committed suicide. In such circumstance, it could be gathered that there is no other prudent reason explained by the accused for the suicidal death of the deceased at her matrimonial home within a year of her marriage. Full stop. We have carefully reappreciated the entire evidence and the reason assigned by the learned session judge.
Yes.
For acquittal of the accused. According to us, the view taken by the learned session judge is not a plausible one. Full stop.
One more submission, my lord.
As such,
After the opinion of the doctor, that is PW 22, my lords. After that, the Department of Forensic Medicine also opined that.
death is not in dispute.
Yes.
Death is
So
not-
ligature marks.
That is not in dispute. Full stop. Is not a plausible one. Full stop. As such, interference is called for in the impugned judgment. Against impugned judgment. Against this backdrop, we answer point number 1 in the affirmative, and point number 2 in the negative, and proceed to pass the following order. Full stop. Full stop. Next, the criminal appeal number
47.
20047 of 2015 is allowed. The 20047 of 15 is allowed. The acquittal judgment passed by the Court of Additional District and Session Judge at Bidar in SC number 5 of 2014, dated 1/12/2014, is set aside. The accused number 1 and 2 are convicted for the offence punishable under section 498A, 304B, read with section 34 of IPC and section 3 and 4 of Dowry Prohibition Act. To hear on sentence. ಕರೀರಿ ಅವರನ್ನು. ಇವತ್ತೇ ಮಾಡ್ತಾರ ಕರಿ.
ಅವಿನಾಶ್ ಶುಕ್ಲಾಂಕ.
ಕರೀರಿ ಅವರನ್ನು, ಅವರಲ್ಲಿ ಹೇಳಿಬಿಡಿ ಹಿಯರ್ ಆನ್ ಸೆಂಟೆನ್ಸ್ ಮಾಡ್ತಾರ. ಇವತ್ತೇ ಮಾಡ್ತಾರ ಏನಂತ.
Serial number
44. Just wait, I'll take.
serial number 5, Gigi Chagashetti.
Password.
Serial number 60.
My lord,
Arun Kumar Amargundappa.
in this appeal, I have filed a application under Order 41, Rule 27, seeking to, my lord, lead oral evidence of the appellant who was respondent before the trial court in a petition filed by husband.
I'll pass over. We'll hear it. Any of that IA will consider along with the main one.
My lord, may make this request, my lord. At least keeping this appeal, my lord, pending.
At the time of hearing, we'll hear the matter. During the course of hearing, if we find that we need to give you an opportunity, we'll give you an opportunity. Otherwise, no.
Yes, that apart, my lord. My submission is, in view of, my lord, counsel's oral submission before the trial court, to the effect that, my lord, alleged cruelty and desertion is to be proved by the petitioner himself. Therefore, my lord, he stated that no evidence from respondent side is required. However, my lord, trial court comes to a conclusion that, my lord, I have failed, this respondent wife has failed to prove the allegations by leading evidence. That is there on record itself, my lord.
So that we'll see. Pass over.
Please.
Number 22, Prashant Vajantri.
For the petitioner,
Yes.
yesterday Lordship directed the government to, my lord, find out.
Pass over.
Seal number 30.
Appearing for petitioner.
Yes.
My lord, the petitioner was appointed as a physical teacher. My lord, on 24/3/2022, the petitioner was appointed as physical teacher, my lord, as per annexure A1. Page number 19, my lord, serial number 3, the name of the petitioner found, my lord. To direct recruitment, my lord, he has been appointed.
So this is an order of transfer.
No, my lord, this is the appointment order, my lord.
No. You're challenging order
Yes,
of.
my lord, I am challenging annexure A9, my lord, before the honorable tribunal, wherein, my lord, the transfer order has been called in question on 3 grounds, my lord. One is that, my lord, on premature. Second one is that, my lord, I have been appointed, my lord, through direct recruitment, and, my lord, as per transfer guidelines, my lord, I cannot be transferred, my lord, outside the Hyderabad Karnataka region for 10 years, my lord.
No, Tengli. The transfer matter, you complete a instruction. We'll have it on Tuesday and we'll close it. Huh? Now, on what grounds you have been transferred or you have challenged the transfer?
On 3 grounds, my lord.
What are the grounds?
One is premature, my lord. And
Appointed previously on
my lord, on 2022.
2022,
I am Group C employee, my lord.
you are a Group C.
Yes, my lord.
How many years?
4 years is there.
24/3/2022.
22.
So till 26, you cannot be disturbed.
Yes, my lord.
When were you ordered for transfer?
Annexure A9, my lord, dated
3/7/23.
10/10/24.
10/10/24. You're saying this is a premature.
Premature.
You are a government employee.
Yes, my lord. Second ground is that, my lord, I have been appointed, my lord.
The schools follow the same policy or different transfer policy?
I ascertain, madam. It is
Fine.
Abdul Kalam ಶಾಲೆ ಅಂತ ಇದೆ.
There must be some other, not government employee transfer.
ಅಲ್ಲ ಅದು ಟೀಚರ್ಸ್ ಗೆ ಗವರ್ಮೆಂಟ್ ಟೀಚರ್ಸ್ ಗೆ ಟೀಚರ್ಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್ 2020 ಸಪರೇಟ್ ಇದೆ ಒಂದು. ಬಟ್ ಇದು ಅಲ್ಪಸಂಖ್ಯಾತರ ಕಲ್ಯಾಣ ಇದರಲ್ಲಿ ಇವರಿಗೆ ಬರಲ್ಲ ಇದು.
Exempt.
ಇವ್ರಿಗೆ ಬರಲ್ಲ ಬಿಕಾಸ್ ಇದು
234. Respondent number 2.
ಅಲ್ಪಸಂಖ್ಯಾತರ ಕಲ್ಯಾಣ ಹಜ್ ವಕ್ಫ್.
No, you're saying you're exempt from applicability of transfer guidelines.
Not exempt, those are not applicable to these melody.
Then what are the rules that apply?
That is the transfer guidelines, melody annexure A10, the applicable to the government employees, 25/6/2024. That is the new transfer guidelines.
No, but these teachers, they have some counseling, etc. That doesn't apply to you.
Melody, as per my instruction, melody, this is not applicable.
You find out.
This is these schools comes under respondent number 234, my lord. Department of Minorities Hajj Waqf. APJ Abdul Kalam School
Residential
to
school.
transfer to Moraji Desai School.
Who represented them?
Where ಇಲ್ಲಿ
Separate council, not
Yes,
government.
madam. They are having separate council.
Separate council.
2-3 na? Respondent of 2-3.
2, 3, 4.
Then you take out notice, you serve them, we'll have it on.
My lord, one submission.
Huh.
I had the benefit of interim order before the honorable tribunal, my lord. Your lordship may hear it on Tuesday, my lord. Till then, my lord, I may not be, because my application has been dismissed on the ground that, my lord, my principal contention is that, as per the transfer guidelines, my lord, from the date of appointment, my lord, where, my lord, I have been posted to the Hyderabad Karnataka region to a vacant place at my initial appointment, my lord, I cannot be transferred, my lord, for minimum 10 years, my lord, within the outside the Hyderabad Karnataka region, my lord. That is the my main ground, my lord. And it has been stipulated in the transfer guidelines also, my lord, clause 6-2, my lord.
Clause?
6-2 of the transfer guidelines, page number 43. ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶದಲ್ಲಿ ನೆಲೆಸಿರುವ ಕಚೇರಿಗಳಿಗೆ ಸ್ಥಳೀಯ ವೃಂದ ಮತ್ತು ಮಿಕ್ಕಿಳಿದ ವೃಂದಗಳಿನ ವಿವಿಧ ವೃಂದದ ಹುದ್ದೆಗಳಲ್ಲಿ ಖಾಲಿ ಇರುವ
So in only
Here he
Hyderabad-
was, my lord, he was appointed as physical education teacher. And
class
he was
6-2.
assigned to work as a computer assistant on, my lord, probationary basis. And that period is completed. Now he was transferred to the original cadre of physical education teacher to
Elli?
the Morarji school.
Where?
Morarji
ಅಲ್ಲಿ
school.
ಎಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ
Outside the.
ತುಮಕೂರಿಗೆ ಹಾಕಿದ್ದಾರೆ.
Outside Hyderabad.
Yes,
Karnataka.
yes, my lord, ತುಮಕೂರಿಗೆ ಹಾಕಿದ್ದಾರೆ.
Now what is this is your best ground, isn't it?
Yes, that is my main ground.
Just one saku. Now the tribunal, what is the tribunal?
Tribunal holds that, my lord, after completion of my probationary period, my lord, I have been,
Won't apply.
don't apply, my lord, I have been transferred to my original place. That is, my lord, what happened, my lord?
Physical teacher anta.
I have been appointed as a physical teacher in the fourth respondent, posted to the fourth respondent school, my lord.
Your original appointment was on basis of reservation under 371J, na?
Illa.
Alla. My original appointment, my lord, to the non-HK region, my lord.
Yes.
HK region ಗೆ ಅಪ್ಲೈ ಮಾಡಿಲ್ಲ. ನಾನ್ HK ಕೋಟಾದಲ್ಲಿ HK ಗೆ ನಾನು ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟಿದ್ದು. ನಾನ್ HK ಕೇಡರ್.
You are appointed under what quota?
Under the non-HK ಕೋಟಾ, my lord.
ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸಿ. ನಾನ್ ಅಂದ್ರೆ ಜನರಲ್ ಮೆರಿಟ್.
Please, my lord.
ಜನರಲ್ ಮೆರಿಟ್.
He is general merit.
Allala, because if I apply for HK quota, my lord, then I will be appointed in HK quota.
No, correct.
I have not applied for it because I am not resident of Hyderabad Karnataka region.
So you didn't claim benefit of 371J reservation.
No, not claimed, my lord.
Isn't it?
Yes, my
So in open category.
Yes,
You
open.
were selected.
Yes, my lord.
Then how
Open.
okay. And
Yes.
then you were, your first posting was at
Yadgir, that is Hyderabad Karnataka region.
Yadgir. Now this clause 2 of 6
Yes, ma'am.
applies to those who are selected under open category as well. That is your contention.
Yes, ma'am. You are kindly see, my lord.
Yes.
ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶದಲ್ಲಿ ನೆಲೆಸಿರುವ ಕಚೇರಿಗಳಿಗೆ ಸ್ಥಳೀಯ ವೃಂದ, ದಟ್ ಈಸ್ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ, ಮತ್ತು ಮಿಕ್ಕಿಳಿದ ವೃಂದಗಳಲ್ಲಿನ ವಿವಿಧ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗಳೆದುರಾಗಿ ನೇಮಕ ಹೊಂದಿರುವ ನೌಕರರನ್ನು ಅವರ ನೇಮಕಾತಿ ದಿನಾಂಕದಿಂದ ಕನಿಷ್ಠ 10 ವರ್ಷಗಳವರೆಗೂ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶದ ಹೊರತುಪಡಿಸಿ ವರ್ಗಾವಣೆ ಮಾಡಬಾರದು.
If he is appointed.
So you are saying that once the office is situated in this region,
Please.
Hyderabad, Karnataka, and you have been posted there,
Yes, madam.
then in terms of 6(2), you cannot be shifted for a period of 10 years.
10 years from outside, I can be transferred within the Hyderabad Karnataka region, madam.
Correct, you can't
Yes.
go outside.
Yes, madam. Now I have been transferred to Tumkur.
That was your main contention.
Means.
What does the tribunal hold?
Tribunal holds that, my lord, my lord, what happened, I have completed my probationary period. Thereafter, I have been, my lord, your lordship, kindly see, my lord, my first appointment, where I have been, my lord, posted to the 4th respondent school as a physical education. Thereafter, my lord,
No, now this clause appears to say if the office is situated.
May I read one para, my lord?
my lord, illa, one clarify, one clarify. Why, my lord, the tribunals holds, my lord, the, on annexure A3, my lord, on 3/7/2023, in the very same school, my lord, page number 25, annexure A3.
Ah.
In the very same school, I have been, my lord, deputed to work as a computer operator, my lord. It's serial number 7, my lord, on one pay scale. In the very same school, my lord.
Yes.
Thereafter, my lord, as per annexure A5, page number 30, while working, my lord, as computer operator, I have been transferred to Raichur district, Gillesugur, page number 30, serial number 3.
Correct. That is also within Hyderabad, Karnataka region.
Within Hyderabad, Karnataka, where there, my lord, the person, my lord, with my lord, in whose place I have been transferred, my lord, that person has called in question this transfer order before the honorable tribunal as per annexure A6, my lord. And the honorable tribunal, my lord, granted interim order. Thereafter, my lord, the application has been allowed. Therefore, by virtue of the setting aside this transfer order, my lord, I am continuing in the same place, my lord. In the same place as a computer operator. Now, my lord, the tribunal holds that, my lord, I have been completed my probationary period. Therefore, I have been.
Correct. That's okay. What does the tribunal say with respect to this provision? Does it refer to this provision?
Yes, referred and.
What does it say? Let us.
Yes, my lord. On perusal of, my lord, para 6, my lord.
Yes.
Page number 49.
Yes.
On perusal of appointment order, it is revealed that the applicant was posted to Yadgiri district on probation on training on 24/3/22. After completion of period of 2 years, he was posted to Gillesugur, Raichur district, which was challenged, and he continued at Balched as first division computer assistant on his own pay scale. The applicant is appointed as physical education teacher and was given posting at computer assistant. After completion of 2 years of training and probation, he is rightly posted to his original designation, which is physical education teacher.
Now, the tribunal appears to have held that post to which he was appointed was not against
the Hyderabad.
in Hyderabad, Karnataka.
The very appointment order, that is what I am submitting, my lord. The appointment order may kindly be perused, page number 18, annexure A1. There is no a single whisper, my lord, he is appointed.
No, just look at it. His contention is only this. If the office is situated in Hyderabad,
Within the, yes.
according to him, that's his contention. Under 6(2), if the office is situated in Hyderabad, Karnataka region, whatever quota, either general merit or otherwise, if you are posted there for 10 years, you must be only within the Hyderabad, Karnataka region. Perhaps people who are posted here are ready to run away and come back to Bangalore. That may be the logic of this. So wherever an employee is placed in this, for 10 years, he must go only within, that is what is in. That requires some consideration. Let us see. That's all
For
your
a moment,
contention.
one para, my lord, for that reason I am submitting. Tribunal has come to the
Tell me,
conclusion.
tell me.
Page number 19.
Ah.
ಸರ್ಕಾರದ ಉಲ್ಲೇಖ 4ರ ಆದೇಶದಂತೆ page number 19, annexure A1, second page. Ink page 19, my lord.
Yes.
ಸರ್ಕಾರದ ಉಲ್ಲೇಖ 4ರ ಆದೇಶದಂತೆ ಅಲ್ಪಸಂಖ್ಯಾತರ ನಿರ್ದೇಶನಾಲಯದಲ್ಲಿ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದ ಮೂಲಕ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ಶಾಲೆಗಳಿಂದ ದೈಹಿಕ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಇರುವ ಈ ಕೆಳಕಂಡ ಅಭ್ಯರ್ಥಿಗಳೇ ಸ್ವಯಂಸೋ 2 ವರ್ಷಗಳ ಕಾಯಂ ಪೂರ್ವ ಸೇವಾವಧಿಗೆ ಒಳಪಟ್ಟು ಷರತ್ತುಗಳನ್ವಯ ಅಭ್ಯರ್ಥಿಗಳ ಜ್ಯೇಷ್ಠತೆಗೆ ಹಾಗೂ ಮೀಸಲಾತಿಗಳ ಆಧಾರದ ಮೇಲೆ ಅಭ್ಯರ್ಥಿಗಳ ಸಹಮತಿಯೊಂದಿಗೆ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ಸೂಚಿಸಲಾಗಿರುವ ಸ್ಥಳಗಳಿಗೆ ಪರಿವೀಕ್ಷಣಾ ಅವಧಿಯು ತರಬೇತಿ ಹಾಗೂ ಕರ್ತವ್ಯಕ್ಕೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಆಗಿದೆ. For the probationary period of 2 years only, this order itself speaks. Now the 2 years probationary period is completed.
But
That Hyderabad, that I
point
have
has
to
to be
ascertain, my lord.
clarified. The counsel for the petitioner would submit that in terms of 6(2), ಅದು full ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಗೈಡ್ಲೈನ್.
Please, madam.
ಒಂದರಿಂದ page 4 ಜಂಪ್ ಆಗುತ್ತೆ. 810. In terms of 6(2) of the government order dated 25/6/2024, the posting to a posting given to an office situated in Hyderabad, Karnataka region would result in detention of such employee within the region for a minimum period of 10 years. Full stop. It's submitted that this aspect has not been taken note of by the tribunal, which has opined that after the probation period is over, petitioner could be transferred to any place even outside the Hyderabad, Karnataka region. Full stop. In light of the contention raised, there would be a stay of
Annexure A9, my lord.
Annexure A9
A9
till the next date.
in respect of petitioners.
In respect of the petitioner till the next date.
Please.
Issue notice.
I take for
Now,
respondent
who
number one.
appears? AGA appears,
One.
accepts notice for respondent 1. Then
2, 3, 4 notice has to go.
emergent notice to 2, 3, 4. Petitioners at liberty to serve. Counsel who appeared in that.
ಅಲ್ಲಿ
Emergent notice. Any of Busare is
ಅಲ್ಲಿ
happy.
served and unrepresented ಆಗಿದೆ.
He's happy. ಹೋಗ್ಲಿ notice. Release. Week after next.
Please.
You replace this.
Please, my lord. I'll replace. Sorry, my lord.
Tatkal scrutiny. ಅದು replace ಮಾಡಿ page number ಹಾಕ್ಬೇಕು.
Please, please.
Sorry, my lord, 7 in the morning when the matter was gone.
Any scope for settlement?
I tried, my lords. In the beginning, there was an offer from the other side. Even I had also agreed. But I would go and settle in Bombay along with her, my lords.
You are ready?
Later on, I was ready. But later on, my lord, she did not call me at all. She did not receive even a phone call, my lord, when I got ready to go to her to join, my lords. After that, my lords, something transparent, he is not ready to join her there.
Correct.
Because it was an understanding. It was during vacation, my lords. And she did not even pick the call when I got ready to go and join there in Bombay. So now that, my lords, it seems to be impossible that he would go and join her in Bombay and stay at home, my lords. If she is ready to come, my lords, that also seems to be impossible. She will not leave the job and come here.
So what is the way forward now?
There doesn't seem to be any.
North Pole and South Pole will not meet. So now what you have to propose, you have to say. Adjudication we can, but it will not.
Serve
in
no
any-
purpose, my lord.
It will not serve any.
She could,
Either join or depart peacefully.
I am ready, my lord, but
Children
she
are-
is not ready to
Huh?
divorce me.
Children is there?
I have
He is
filed
ready.
divorce. One
Always
daughter
ready
is there.
to join him.
Huh?
She is ready to join him.
ಅಲ್ಲಿ ಎಲ್ಲಿ ಬರಕ್ಕೆ ಇಲ್ಲಿ
ಈಗನು ತಯಾರಿದ್ರೆ ಮುಂಚೆನೂ ಇದ್ಲಕ್ಕೆ.
ಇಲ್ಲಿ ಬರಕ್ಕೆ
ಇಲ್ಲಿ ಬರಲ್ಲ.
ಇಲ್ಲಿ ಕೆಲಸ ಬಾಕಿ ಏನ್ ಕೆಲಸ ಇಲ್ಲ.
ಅದು ಪ್ರಾಬ್ಲಮ್.
CS ಇಲ್ಲಿ ಕೆಲಸನೇ ಸಿಗಲ್ಲ ಅವ್ರಿಗೆ, ಅವನಿಗೂ ಕೆಲಸ ಇಲ್ಲ.
ವಾಟ್ ಇಸ್ ಶಿ ಸ್ಟಡಿ?
ಅಲ್ಲಿ ಏನೋ
Engineering.
ಇಲ್ಲ ಇಂಜಿನಿಯರಿಂಗ್ ಇಲ್ಲ.
She is an
ಗ್ರಾಜುಯೇಟ್,
engineer.
ಗ್ರಾಜುಯೇಟ್. ಪ್ರೈವೇಟ್ ಫೈನಾನ್ಷಿಯಲ್ ಫರ್ಮ್ ಅಲ್ಲಿ ಏನೋ ಕೆಲಸ ಮಾಡ್ತಾಳೆ. ಇನ್ ಮುಂಬೈ ಶಿ ಇಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ಪ್ರೈವೇಟ್ ಫರ್ಮ್. ಸೊ ಇಲ್ಲಿ ಅವಳಿಗೆ ಏನ್ ಜಾಬ್ ಸಿಗಂಗಿಲ್ಲ. ಅಲ್ಲ ಸಿ ಇಸ್ ಟೆಲ್ಲಿಂಗ್ ಹಸ್ಬೆಂಡ್ ಬಂದ್ ಸ್ವಲ್ಪ ದಿನ ಇರ್ಲಿ, ಮುಂಬೈದಲ್ಲಿ ಕೆಲಸ ಸಿಗುತ್ತೆ, ಬೇರೆ ಮನೆ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲೇ ಆರಾಮ ಇರುವಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್. ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಏನೂ ಇಲ್ಲೇ ಇಲ್ಲ. ಈಗ ನಾವು
ಅಲ್ಲ ಆಯ್ತು, ಒಪ್ಕೊಂಡ್ರೆ ಆಯ್ತು. ಅವ್ರು ಇಲ್ಲಿ ಬಂದು ಅಡ್ಜಸ್ಟ್ ಆಗೋದು ಸ್ವಲ್ಪ ಕಷ್ಟನೇ. ಅವರು ಇಲ್ಲಿ ಬಂದು ಅಡ್ಜಸ್ಟ್ ಆಗೋದು ಸ್ವಲ್ಪ ಕಷ್ಟ.
ಅಲ್ಲ ಇಲ್ಲಿ ಜಾಬ್ನು ಸಿಗಲ್ಲ ಆಕೆಗೆ, ಯಾಕೆ ಮೇಂಟೆನೆನ್ಸ್ ಆಲ್ಸೋ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ಬಿಡುತ್ತೆ. ನಾಳೆಗೆ ಮಗು ಇದೆ, ಸೆಕ್ಯೂರಿ ಏನಾಗಲ್ಲ, ಎಜುಕೇಶನ್ ಆಗಲ್ಲ ಎಲ್ಲ.
Then you only figure out what is to be done.
If she is ready for claiming any permanent alimony, I'll advise him. Or she likes to join me,
Huh?
I can advise him. But
Permanent
that
alien ಬೇಡ
doesn't
ಅಂತ
seem
ಇದೆ.
to be possible.
ಇದೇನ್ ತಪ್ಪೇ ಇಲ್ಲ. ವೈ ಶುಡ್ ಐ ಸೀಕ್ ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್ ಅಂತಾಳೆ. ಇರ್ಲಿಕ್ಕೆ ತಯಾರಿದ್ದೀನಿ ಬರ್ಬೇಕಂತ
ನೀವು
ಸ್ವಲ್ಪ ದಿನ.
ಅಲ್ಲಿದ್ದೆ-
ಸಮ್ ಟೈಮ್ಸ್ ಹಿ ಮೇ ಕಮ್. ಮೊದಲ ಬರ್ಲಿಕ್ಕೆ ತಯಾರಾಗಿದ್ದು ಈಗ ಎಲ್ಲೋ ಹೋಗಿದ್ದಾನೆ ಮತ್ತೆ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ,
ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ಸಮ್ ಟೈಮ್ ಟು, ಮಗು ಇದೆ
ಅಲ್ಲ,
ಬರ್ಬೋದು
correct,
ಅಂತ.
but then you must also make some effort. You must say,
ಅಲ್ಲ
I'll come visit at least monthly once. If
ಅಲ್ಲ
you start,
ಅವ್ರು ಎಫರ್ಟ್ ಮಾಡ್ಬೇಕು, ನಾವು ಮಾಡಿದ್ದೆ ಅವರೇ ಬರ್ತಾ ಇಲ್ಲ.
now you come here monthly once, let us see. If at all they are ready to accommodate you, monthly once you come, after 6 months you can see if at all there is some chemistry between both, then it may sustain. If you stay outside, how it's possible to run a relationship through outside?
That
To
would be
talk to
agreeable.
her. If she comes monthly once something, then he'll come monthly once for another 6 months.
ಅವ್ರ ಕಂಟೆಂಟ್
something.
ಅವ್ನಿಗೆ ಏನು ಕೆಲಸ ಬಾಂಬೆದಲ್ಲಿ ಏನಾರ ಸರ್ಚ್ ಮಾಡಿದ್ರೆ ಜಾಬ್ ಸಿಗುತ್ತೆ.
ಅಲ್ಲ, ಆಯ್ತು ಸದ್ಯಕ್ಕೆ.
ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಏನು ಸಿಗೋದಿಲ್ಲ ಅವನಿಗೆ.
May be true, may be
ಸೊ
true.
ದಟ್ ಇಸ್ ದಿ
But at
ರೀಸನ್.
least for the relationship to sustain, monthly once you come and go on one weekend for 6 months, then let him come and go for 6 months, then something can be worked out. If the relationship is to continue, there cannot be long distance relationship. We cannot pull them together. You talk to her.
Yes,
If she feels she wants the relationship for 6 months, once in a month, let her come and go. Then let us see how they receive her.
ಐ ವಿಲ್ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀನಿ.
ನೋಡಿ.
ಟೈಮ್
List up to 2 weeks.
Date.
Yes, my lord. She is on the VC, my lord. Deputy Commissioner. Open ಮಾಡಿ madam.
Till number 5.
Communication, give us a copy of that communication.
Deputy Commissioner. Deputy Commissioner. ಅದು ಓಪನ್ ಮಾಡಿ madam.
ಬೆಳಗ್ಗೆ ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡಿ.
In that case, my lord, we complied the order of the serial number 6 and 7, my lord.
No, 5, we are at 5.
Please, 208, my lord.
5, what has happened now?
5, my lord, notice is served, my lord. Deputy Commissioner is on the line, my lord. Open ಮಾಡಿ madam.
ನಿಮ್ಮ ಫೋನ್ ಅಲ್ಲಿ
ನಂದು ಇದರಲ್ಲಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಬಸ್ ರೆಡ್ಡಿ ಅಂತಿದೆ. Served unrepresented, my lord. Now authorization letter is given to me, my lord.
Why Deputy Commissioner, you have not put in appearance in this matter though notice is served? Why have you not put in appearance though notice is served?
Deputy Commissioner.
Why you have not put in notice though you have served in contempt 2000194 of 2024? You have been served, you have not put in appearance. Why is this? Yes, madam, can you hear us?
Sir, I'm unable to hear, sir. The voice is very feeble.
Why have you not put in appearance despite being served in contempt 2000194?
Sir, we had authorized both the government advocate as well as the assistant commissioner, sir, because she is the land acquisition SLA or the special land acquisition officer, and we have also written to WPWD in this case, sir. My representatives are in the court, sir, with all the original files right now.
No, you are arrayed as a respondent number 1 And you have not put in appearance despite notice being served. There's no intimation to the government advocate. He says he is not aware. And if you are served and your government counsel is not aware, only way is to issue warrant. On what date did you receive the notice? Find out from
Sir,
your
on
records.
Friday, sir, last Friday, my office has written both to the AC as well as the WPWD, sir. It's an old case, pertains to
Madam,
2006.
I am not interested in any explanation.
Sir,
If notice was served on you on Friday, why is it that till today you have not put in appearance, nor your government counsel has any intimation that you have been served?
sir, we have given the government advocate intimation, sir,
When was
by
that?
way of a letter in writing, sir. I'll submit it to the court, sir.
When was that given?
Sir, the original file is presently not with me, sir. The letter, land acquisition. Sir, we have written, sir, to the AC Kalaburagi, to WPWD as well as to the government advocate, sir.
When was that written?
The file code, land acquisition, the file. Sir, I'm just cross-checking, sir. That file, original file has gone. I'm just looking at the Xerox copy. So give me a minute. Date. On 18/1/2025, sir. AC Kalaburagi to WPWD as well as the Additional Government Advocate, Office of Advocate General, High Court of India, High Court of Karnataka, Kalaburagi bench, sir.
The government advocate has no intimation of this.
24/1/2025, notice was issued, my lord.
On 24/1/2025.
How they will write prior to that one, my lord.
Notice was issued by the court only on 24/1/25. I don't know, you are being
Sir,
misled
this
by
is,
your-
sir, with respect to
200,194 of 2024.
I have paid process on this.
yes, sir. Yes, sir. With respect to writ petition 200,800 of 2023, sir.
Wrong, madam. We are in serial number 5, contempt petition 200,194 of 2024.
24. Yes.
Notice was issued by this court on 24/1/2025. So that you could not have issued a letter on 18/1/2025. I don't know what you are being briefed by your administrative staff.
So we have written another letter on the 12th as well, 12th of February, sir. I'm just looking at the Xerox copies on file, sir. I will give a submission in writing along with all the documentary evidence.
No, that is not our concern. You have to make your arrangement. We are not going to invite you to court. Please understand that, madam.
So duly noted, sir.
Now, will you undertake?
Yes, my lord, I will undertake, my
AGA
lord.
undertakes to appear for respondent number 1. Respondent number 1 appears through VC and submits that notice has been served. For necessary compliance, relist the matter on date code is next week. 19th. Next.
Bill number 6, Ratna and Shivyogimma.
This matter, my lord, we comply the direction of the non-single judge, my lord.
But my lord, that is not compliant.
But,
Now in contempt 200,208 of 24, government advocate has addressed a letter to you on 6/11/24. Till date, there is no response. What do you say, madam?
Who's also in this case?
Government advocate has furnished to the court upon our insistence that he has intimated by letter dated 6/11/2024. Till date, you have not put in appearance. What do you say regarding this matter?
Sir, in this case, sir, two cases combined, one order was passed directing Deputy Commissioner to consider the application of the petitioners within a period of 15 days and to pass appropriate orders. Sir. Sir, in this case, sir, the compliance was given, time was given for 3 months. We have issued the endorsement based on a report from the Commissioner GDA. Sir. Since this concerned village pertains to the extension of the local planning area of 2016, sir. There was a technicality involved, so we had asked for the GDA commissioner for a report in this matter, sir. The commissioner, as per the commissioner GDA's report, we have issued an endorsement to the applicants.
No, but you must
The
put in
details of this case was already communicated to the government advocate's officer dated 12/2. By ADC, sir. I was not in headquarters for the past 2 days because I was appearing for 3 important meetings in Bangalore headed by principal secretaries.
Please don't tell us, madam. We are not interested in what meeting you are appearing. That's not our concern at all. One. Two, if the government advocate is not informed, that's not our headache. There is no instruction of the government advocate, and you are solely responsible for answering why government advocate was not, or your official must have intimated the government advocate to put in appearance. Government advocate stands here with no instructions. In a contempt matter, if this is the attitude being shown, what do we have to understand? I really don't know. We definitely don't like this kind of attitude. I have never called you. This is the first time on video conference we are insisting, and the reason
Sir.
is that we don't like this kind of a nonchalant attitude towards the court. Absolute.
Not
no
at all, sir. I apologize if you think that, sir. In fact, about this case also, this information was received by my office only yesterday, sir. But compliance has happened as per the writ petitions.
That may be so, but you must make
Sir.
arrangement that at least some clerk of your office must be present here to show some kind of respect to court orders. Because this
So
is
most definitely, sir, I agree, sir. Intimation was a little delayed. Both there was some miscommunication between the law officers and the administrative officers. Sir. I will ensure I'll do a coordination meeting amongst all of them and ensure that compliance is henceforth submitted in a timely manner. Sir.
AGA.
Lord, I filed the memo, my lord.
AGA undertakes to appear for the GA undertakes to appear for the respondent number 1.
Please.
Memo filed
Yes.
along with the documents, and it is a submission that there has been compliance for say of the complainant.
Please.
Yes. Next matter.
Please.
Next matter also same.
Next same.
Yes.
Same order. Yes. Please see that this kind of communication mismatch between you and your counsel should not occur. Somebody, at least through video conferencing, somebody from your office must be present and monitor contempt matters. We are not
Sir,
concerned.
most definitely, sir. I agree, sir. If same directions can be given to law officers also. If we had the information in advance, definitely we would have provided. Sir.
Yes. Yes.
Matter, I have filed additional application. If my lord wishes to hear, my lord's wishes to hear on the main itself, then I have to lay my hands on several judgments with regard to cruelty and all. I was under impression that my lord hearing would happen on interlocutory application. Any date could be fixed, my lord, without fail that day.
Well, have it on Wednesday. You
Please.
come and argue on merits. During the course of
Yes.
argument, if we find that on your IA some orders to be passed, we'll decide.
Please.
Relist on Wednesday.
Please. Great.
In the orders list, my lord.
Huh?
The orders.
Now it's in orders list only.
Please, ma'am.
ಏನ್ list ಅಲ್ಲಿ ಇವಾಗ?
Number 22, come.
The same stage.
No, for the petitioner, my lord.
Yes.
But it's not.
But in the first matter, my lord, may I submit, my lord?
Yes, we can start. The government additional advocate general.
My lord, take permission, my lordship. My lord, yesterday, my lord, in this case, my lordship has directed us to be the provisions with regard to the deputations which applies under the Karnataka Civil Service Rules notification. The section 50, rule 50 is an applicable in this case, my lord. Rule 50, it says about rule 50 subsection 3.
Yes.
50 subsection 3, my lord. Rule 50 it says about deputations to other department.
CCNA, KCSR.
This is a KCSR, Karnataka Civil Service Rules.
Yes.
Section the rule 50, my lord.
Yes, 53.
15 subsection 3. Such deputation should not ordinarily extended beyond the 5 years except under the special order of the government. My lord, in this case, my lordship is aware that there is a different the two department. One is medical department is a separate department and health department is a separate department. The doctors have been transferred from the health department to the medical department. So the 5 years period is exceeded. If the 5 years period is crossing, then the judgment which is relied by the appellant in this case, it will not applicable in this case, my lord. So in the judgment it says only for the 2 years period, within the period they have been the transfer, the deputation. So therefore they want borrower and landing permission is required. But in this case, 5 years is exceeding and therefore the special order is required to be a continue there itself.
So you are saying that this borrowing and lending, etc., consent discussion will happen only if it is within the period of 5 years. Kelsalla. We can't hear you. We can't hear you.
Lord, I'm only on the point, my lord, that there is a need of my services in the first respondent department, and that is the certificate that is issued. And secondly, my lord, since the entire process of counseling is being stayed, my lord, even if I get myself self-relieved, my lord, and report before the second respondent, my lord, they will not be able to give me any posting. So till such time that, my lord, general counseling is held, my lord, I may be permitted to continue in the present place. That is what is my specific contention before the tribunal. Kindly come to page. My lord,
just 1 minute. Just
1 minute. 1 minute, sir. I have not completed. I will complete and then my prayer, my lordship, my lord, the judgment of in the case of the which my learned friend is relying in the Chikkagalli page number 11, my lord, para number 6, my lord. Para number 6, my lord, in that. The deputations list has no legal rights to the post office to which he is deputed as rightly argued by the respondent. But it is not a case for here and therefore the decisions does not come to the rescue of the respondent, especially when the rule 50 KCSR provides for the maximum period of 5 years. Maximum period of 5 years for the deputation. There are some of the government orders, presumably they issued under the rule, which broadly formulated the policy of the deputation and its a tenure. The government order dated 1981, reproduced in the writ petitions and not contributed by the official respondent. The prescribed consultations between the borrowing and lending department are preconditions as cutting short of the tenure, extending the period of the deputation. True, it is that the government order is circular and arguably may not be have force of the law and to given to the contrary to causes of the action for the legal proceedings, but they are provided a standard and with which validity of the administrative action can be assessed. Even this order has not been born in the mind of the first respondent in issuing of the impugned notification. It is only the related five years period only they are related in this case. Well, in this case, within the 2 years, when the officer has passed an order in this within the 2 years period, this is 2017. He is in the department of the department is a PWD to the RDP department is a dispute in this. PWD from the PWD
No, health department.
Now the PWD RDPR department is the two department and 14/6/2017. I am saying about not this case, sir. I am saying about the judgment which you are relying in this case. In the case of CP, Chikkagalli case. Chikkagalli case.
No,
that is within the.
Just 1 minute. Now, insofar as that submission is made, it's well taken. It's a submission that under 53, if it is beyond the period of 5 years, this direction of consent between both does not arise. That's
absolutely, Malad. Even it is not order also, it is not there in that.
Correct.
So
now
within the.
Correct. No, we are on the same plane with you insofar as such submission is concerned.
Please,
second submission he's making, he's saying that apparently the counseling rule.
Transfer through counseling, Malad. 2011 Act and the rules.
Some proceedings relating to transfer have been stayed. So without, where is that order? Bhajantri, which?
Malad, that I have produced at annexure page 76, Malad.
Page?
76, Malad.
76, Malad, annexure 8.
Page 76, that some process of transfer, counseling, etc. has been stayed. So they are saying that even if we are repatriated, without a stay being lifted in that case, they cannot be posted. That you will have to.
Yeah, my humble submission in this regard, my submission, Malad, about this, the observation of your lordship. Malad, this is not a general the transfer. It is only the deputations concerned. Malad, the deputation concerned is the time is already over. I would even 2024 also, it is a general concern. The notification 15/6/2024 is a general concern.
No, we are with you on that. Now, suppose they are repatriated. Will a posting be given to them immediately? Is what you will have to verify and.
Definitely, my lad. That observation, my lad, to be directions saying that within the time limitation has to be replaced. We'll take it.
But the process of counseling itself is stayed by the Honorable High Court, my lord.
Your lordship may be directed within the time limitations. Will be
unless the interim order is vacated. My lord, the impugned order specifically says that I have to get myself self-relieved. If I get myself self-relieved, I have to go and report for the second respondent, and he cannot conduct any counseling. That is my specific contention before the tribunal, my lord, saying that I am ready to participate in the counseling whenever it is held.
Just 1 minute.
Please.
Mr. Mallarao, just verify.
My lord.
Page 76, annexure A8. You just
please,
get instruction whether in terms of annexure proceedings at annexure A8 there is any bar for posting these people. You just find out.
Please, my lord.
We will have it. When do you want it?
20th, my lord, the other matter. 20.
Till such time, let there be an interim order, my lord. Otherwise, they'll initiate disciplinary proceedings against me as per the impugned order, my lord.
No, let us see. Let us see.
There is a specific direction, my lord, that if I don't get myself relieved immediately, I'll have to face the disciplinary proceedings.
Let us see. Let us see.
Page 61, my lord.
No, we'll pass appropriate orders only after hearing. Now we'll have it on 20th. You take
Much
one
of
and one around clearly, because they are saying that unless that stay is vacated as per Annexure A8, they cannot be posted. So till
I understand. I understood, my lord. I will also get instruction with the observation, your lordship, with recharge to Annexure 8 and whether the procedures have been followed by transferring of this or not.
Yes. Relist
Please,
on 20th in the same stay.
please, man. 23rd also same, man.
Yes.
23rd also same.
Yes.
Great one.
Both the matters, my lord.
Yes, both same.
Please.
Order.
For 38, PS Malipati.
Page 30.
PS Malipati.
Week after next.
Number 39, MIL Kulkarni.
Week after next.
40,
One nimsham. 39 week after next.
Number 40, Sharan Basappa Party.
Appearing for applied, my lord. Last date, your lordship directed to give calculation memo, my lord. I have given, my lord, and he has also given memo, my lord, but as per bachelor, it has to be deducted, my lord, 50%.
Where is he?
You was here only, my lord, that.
Karkambani. Pass over.
Number 42.
Please.
CL Kaujalagi.
A few minutes. Date ID.
Number 42, CL Kaujalagi.
Issue notice to respondents. Registry is directed to secure the trial court records.
Number 43, KM Bhate.
Appears for the correct
So partition suit, my lord, is appeal filed by the defendant. This was only a residential house, my lord. Partition was also already done. There are two daughters and wife left by deceased, my lord. And one of the daughter was given compassionate appointment, and another daughter was given the residential house which was there, my lord. And accordingly, mutation entries were already changed on the name of appellant herein. Subsequently, my lord, mother gets U-turn and she gets to file a suit for partition, along with her one more daughter. And one more daughter, my lord, she becomes just a formal party to the partition suit. She did not participate her claim, my lord. Now the trial court, my lord, by disbelieving all the municipal entries which have been carried out on the name of defendant, appellant herein, my lord, has granted a share in the property, my lord. Therefore, my humble submission, my lord, the matter which was already amicably settled between the parties.
Pre-existing partition,
Yes, my lord.
evidenced by
Evidenced by mutation entries, my lord. No objection affidavit. Mutation entries on the name of appellant herein. And appellant herein was given construction permission to.
Did you set up such defense in a written
Yes, my
statement?
lord, I have set up the defense. I have marked all the documents. And I have also cross-examined the mother regarding those documents, my lord. All those documents were properly marked, my lord.
What is the finding of the trial court?
Finding of the trial court, my lord, under section 17 of the Registration Act.
Not
So in the-
registered,
Yes,
not registered.
not registered. So because of that, those documents may not be accepted. My respectful submission, my lord, when the parties, they themselves don't wanted to create a litigation at the first instance and amicably had their settlement reported to the competent authority, my lord. Because competent authority was the municipal commissioner to effect the mutation. He gets affidavit of both the daughters and mother, my lord.
That is marked, is it?
Yes,
Some
all these affidavits are marked.
marked.
Yes, everything is marked.
Okay, take out notice.
Yes, I sought for interim stay of the, because the court has directed to draw the final decree and measure the property. It is only residential house, my lord. And I am residing. If meanwhile, if something is, my lord, disturbed, then I will be totally out of the house, my lord. Admittedly, there was a open plot and ground floor. Now I have made second floor construction.
Learned counsel appearing for the appellant submits that the parties had entered into a settlement and the trial court, disregarding the same, has proceeded to partition the property. Full stop. Further submitted that the settlement was evidenced, was acted,
2015, it was done, my lord.
was acted upon,
23 suit is filed.
was acted upon, and revenue entries changed pursuant to the oral settlement.
Please, my lord.
In light of the contention raised, there would be stay of the judgment and decree till the next date. Issue notice to the respondents, TCR to be summoned forthwith.
Much obliged.
Number 44, Mantesh Patil.
Password, my lord, held up in court.
Password.
Please.
Number 45, Manjunath Malaya Shetty.
Lord, for appellant, Lord, appeal filed by the corporation, Lord, challenging the contributory negligence. Lord, I sought for stay, my lord, I will deposit 50% award amount. But claimant, they can withdraw.
Issue notice to respond number.
Lord,
Counsel is there, issue notice to respondent.
please.
The operation and execution of the improved award state subject to appellate depositing 50% of the award amount within 2 weeks from today before this court.
Please.
On such a deposit, the respondents are permitted to withdraw the 50% of the deposited.
Please.
Full 50%. Permitted to withdraw. ಏನಿಲ್ಲ ಕೇಸ್ ಅಂತ ಅವರು.
Number 50, additional SPP, Avinash Flankar.
ಇದೆಯಾ ಏನಾದ್ರು ಸೆಂಟೆನ್ಸ್ ಬಗ್ಗೆ ಕನ್ವಿಕ್ಟ್
Lordship, serial number 46.
one counsel for the appellant. Here also. Counsel for the appellant submitted that the alleged incident occurred in the year 2013, and as on this date, the accused are on bail, and there is an aside from them to tend the needs of the family. Further, accused number 2 hailing from old age elements. She is age established. Hence, the lenient view may be taken. The lenient view may be considered while imposing. Lenient view may be considered while imposing sentence. Per contra, the learned additional SPP submitted that the owing the minimum action of the accused, a young girl of 21 years.
Yes.
Girl aged about 20 and 21 years was compelled to commit suicide within a year of her marriage. Full stop. For the financial it's on financial need and urge of the accused, the deceased committed, ended up her life. Hence, he prays to impose the maximum sentence. Having heard the learned counsel for the respective parties, so also on careful perusal of the entire fact and circumstance of the case, since the appellant number 2, that is the accused number 2, is aged about 68 years, we are of the considered view that imposing the minimum sentence prescribed for the offence punishable under section 304B of IPC and other offences would meet the ends of justice. For sure. Next part. Accordingly, we pass the following order. The accused number 1 and 2 are sentenced to undergo simple imprisonment for a period of 7 years, and also minimum 7 years, Alva?
Minimum, sir.
7 years.
Maximum is life.
And also shall be liable to pay a fine of rupees 10,000 each. 10,000 each. In default of payment of fine, they shall undergo simple imprisonment for a period of 3 months for the offence punishable under section 304B of IPC. Next, the accused number 1 and 2 are sentenced to undergo simple imprisonment for a period of 2 years and shall also be liable to pay a fine of rupees 10,000 each. In default of payment of fine, they shall undergo simple imprisonment for a period of 1 month for the offence punishable under section 498A of IPC. Next, the accused number 1 and 2 are sentenced to undergo imprisonment for a period of 5 years and shall also liable to pay a fine of rupees 10,000 each. In default of payment of fine, they shall undergo SI for a period of 2 months for the offence punishable under section 3 of Dowry Prohibition Act. Next, the accused 1 and 2 are sentenced to undergo imprisonment for a period of 3 months and shall also be liable to pay a fine of rupees 1,000 each for the 1,000 each, in default of payment of fine, they shall undergo simple imprisonment for a period of 10 days for the offense punishable under section 4 of Dowry Prohibition Act.
Yes.
Act. Next, all the substantive sentence shall run concurrently. Next, the accused number 1 and 2 shall surrender before the session court, that is the additional district and session judge at Bidar within 4 weeks from the date from the date of 4 weeks from the date of receiving the certified copy of this order, this judgment, to undergo the sentence, full stop. Failing which, the learned session judge is directed to secure the presence of the accused and to commit them to prison full stop. The registry is hereby directed to send the TCR track out records forthwith along with the certified copy of this judgment to the learned session judge to take appropriate action.
Much of it.
Yes, PP.
Please.
Now we can take 1 or 2 appeals.
We are winding up.
Almost.
So we'll just take up other small matters.
Please.
Your quota is more than over.
Yes. Now, even the Nadagi will take up your appeal anyhow. It's over. Judgment agile. We heard you. So we
Monday.
Your appeal. So you want to submit anything else?
That's it, maybe taken up on Monday. I'll finish off my submission.
Anything else to argue?
I have almost completed my submissions.
So as far as that women folks are concerned,
Yes, yes.
number 5
They-
and 6.
Fine.
5 and 6.
I have submitted that there is no consistent evidence to bring them under the ambit of
Injuries on the dead body.
injury. There are injuries. Unless their participation is proved, they cannot be convicted under section 302.
On the evidence that the hostile witness.
Hostile, it becomes evidence, my lords. It becomes evidence because even if the suggestions made by the public prosecutor is perused, not even their names are referred to by the learned public prosecutor who conducted the trial before the sessions. Now they have to explain as to what was the reason.
What is their, how old they are?
Lords,
5 and 6. But how will you overcome from the injuries?
there is also apart from the,
Speak evidence of the doctor that they have sustained.
of course, my lords, that I am not disputing the injuries on the deceased or on the injured.
The injury caused
My
by
lords,
you,
my
injury caused by you,
my lords,
5 and 6.
there are contusions, there are lacerations. Contusions can even be caused by a stone. It is the case of the prosecution that one of the accused used stone as a weapon. Insofar as cut injuries are concerned, the axes have been used in the assault, so that matches the whole thing. But my lords, they have been roped in just because they happen to be the wives of accused number 1 and 2 respectively. My lords, my lords, as
That the accused number 1 to 4 are concerned.
I have not even made submission on their in that regard. Lords, I know the restrictions of my case. Yes, yes. Again, I rely on the evidence of PW8 and PW11. In my humble view, they are the two important witnesses who clinches the issue in favor of accused numbers 5 and 6. Accused number PW8, as an afterthought, adds the names of accused numbers 5 and 6. And if the cross-examination of PW11, the Amanna Kolapur, is perused, the counterpart of my learned friend who was there before the sessions court, he has not even referred the names of these two accused numbers 5 and 6. That is a serious lacuna, my lords. That becomes evidence on record. How do they explain this important lacuna? Not their names have not been even referred to in the cross-examination while giving suggestions to this witness. Hostile witness. Now, my lord, the Supreme Court is very clear insofar as the hostility of witnesses is concerned. So much of the evidence that is helpful to either the prosecution or the accused has to be considered. That are the my lord, yes, he turned hostile. He was contradicted by the prosecutor by referring to his 161 statement made before the police. And the names of accused number 5 and 6 are not even referred to.
Those injuries are whether such suggestion made to the doctor that whether the injuries found on the corpus.
Yes, yes, he made.
Caused by the weapons.
Weapons were shown in the usual course. The weapons were shown, and the doctor. It's after all an opinion evidence. Such weapons could cause the injuries, as noted in the PME or the wound certificate. Is the answer given by the doctor?
By stones.
Stones, the axes and bamboo sticks, and my lords, the basic issue over here is when men folk are armed with lethal weapons. I again reiterate my submission. They are armed with lethal weapons, indiscriminately assaulting with axes and stones. Why would the women folk even think of entering that arena? Lord, just the natural conduct. I am on the natural conduct. Lords, any woman would shudder even to enter that arena when men are armed with lethal weapons like axes and stones. Just keep away from such. So the evidence is not consistent enough to bring them.
To discard the evidence of this material eyewitness.
How?
1, 2, and others.
1, 4 are the crucial witnesses.
1 and 4.
4.
So now once again the court has to rely the evidence of the hostile witness.
Hostile witness and the evidence of another eyewitness who has supported PW8. How? My lords, he at the first instance he says only 4 accused persons were there. That the PW8 who
supported.
He has supported. He says 4 persons were assaulting deceased. My lords, that would be the natural answer from the witness box. There were only 4 persons. Otherwise, he could have very easily taken, no, all the accused were there and they were armed. He says 4 persons. As if it seems that suddenly he remember something prompted him to say, yes, women folk were also there. And my lords posed a very pertinent question. Can the women folk be segregated from all these acts when 149 is invoked? Lords, 149 can very well be converted into section 34 of IPC, common intention. If their presence is ruled out, if the presence of women folk is ruled out, then they can certainly be brought under section 34 of IPC. Other accused, 1 to 4.
Now what is their age? How old they are?
Lakova is, by that time 35, now she's 45, 47, my lords. And accused number 5 is 40, 53, 55. Fifty-five, 45.
Now aged about around 55. For 55 and 45.
55.
55 is accused number 5. 45 is accused number 6.
Because the doctor PM report shows that death is due to injuries.
Injuries.
That is the unfortunate thing.
27.
The doctor has said not because of head injury or any specific. Then you would have bifurcated the act.
Cumulative effect of the injuries, cumulative effect, hemorrhagic shock.
To the entire full body.
Yes, yes, yes.
That is the problem.
Yes.
Place some judgments, sir, nowadays.
Yes, ma'am.
Segregate the act. To bifurcate the act.
149 and 30.
149. The recent judgment of the apex court that even the accused are, the presence of the accused.
Is merely
Presence and some role.
No, recent 2021, 1 month prior.
To be a member of unlawful assembly. Presence.
Such intention.
Yes.
With such intention.
Yes. That's all.
Place some documents, place some judgments.
Please.
Monday.
Good.
At least to save those 5 and 6.
Please.
Yes.
So rest of the accused are concerned.
I don't have a case. It would be a futile attempt.
Yes, Mantesh. You kept us waiting. Yes. Now the appeal is against what judgment?
Lords, the appellant herein is the plaintiff, my lords. Filed suit for permanent declaration and permanent injunction, my lords. Against the defendant respondent herein. My lords, just in the synopsis itself, I have narrated entire how the dispute has started.
Yes, take us through.
My lords, 26/11/1981, my lords.
Yes.
The Town Planning Authority Kalaburagi approved layout plan in survey number 71/1, my lords. As per the plan, plot number 31 to 37 allotted to the Arun Kumar, that is brother of the Ashok Kumar, my lords. 8/2/1983, the vendor of the defendant, my lords, Kirtama purchased
So
plot
Ashok
number 27.
Plaintiff is?
Plaintiff is, my lords, who is the purchaser from the Arun Kumar, my lords. There are 3 sale deeds are there. I am the third purchaser from the Arun Kumar.
Purchaser from the defendant?
Not my lords, defendant, Arun Kumar. What happened is, my lords, there were total 37 plots were made in the 1981 plan, my lords. 31 to 37 were allotted in favor of Arun Kumar. My lords, 21 to 30 plots were allotted, 23 to 30 plots were allotted in favor of Pambava. That is vendor of the defendant. Now what the dispute is started is, my lords, I purchased the plot number 31 from the Arun Kumar. The defendant has purchased the plot number 27 from the Ambava, that is sister of my vendor. Then, my lords, in the year 1983, this 31 my vendor has Veera Kumari purchased. Thereafter, in the year 1992, my lords, there were some extent of the and boundaries were wrongly entered in the sale deed. The correction deed was my lords, made and it was duly registered from the Arun Kumar itself.
Thereafter, my lords, 1992 ದಲ್ಲಿ Meera sold the property to Chandulal. Then I purchased it from the Chandulal. Now the dispute is the plot number 27 defendant. Only in the year 2019, my lords, there was a correction deed was entered at item number 9, my lords, I have mentioned. The plot number 27 was converted into plot number 31 by way of rectification or correction deed, my lords. And boundaries were altered. Thereafter, the earlier to this, the defendant has obtained construction permission. Kata was made in respect of the plot number 27.
What is the trial court?
Trial court, my lords, issue number 1 is answered in the affirmative.
Regarding the
Page number by my ownership.
regarding rectification deed, what is the court held?
A ratification of the deed, my lords, the court has first there was no issue was framed for particularly that issue material facts which were denied by the defendant concerned. And the second is, my lords, the court though held dealt with that aspect but failed to consider exhibit P2 town planning authority map, my lords. That is the crucial document.
Now, who is in possession?
Now we are in possession, but we had a benefit of injunction order throughout the proceedings. Along with IA, my lords, I produced, and the miscellaneous appeal, first appeal filed by the defendant is also dismissed, my lords.
That is against the IA during the pendency of the suit.
IA which was granted in my favor.
Where is the MFA copy?
I have annexed with my application, my lords.
200516.
House.
This was filed by the
defendant. Para number, my lords, 7. This court has observed.
Yes.
Page number 7. Upon meticulous examination of the evidence presented, this court finds that the defendant's vendor purchased plot number 27, which was subsequently acquired by the defendant. Meanwhile, the plaintiff has legally purchased plot number 31. The defendant is now claiming plot number 31 based on ratification deed executed by her vendor. The defendant's claim to plot number 31 rests on a ratification deed, which has yet to be judicially scrutinized or validated as a basis for the title transfer. Generally, ratification deeds are used to correct errors in legal documentation, not to substantially alter property boundaries or ownership. Allowing the defendant to act on this presumptive claim by the undertaking construction could give undue weight to a contested document, potentially resulting in injustice to the plaintiff. If a defendant
It was a vacant site.
It was a vacant site.
Now they've entered into, is it?
Now they are trying to, my lords, put up a construction. When I have photographs. When they started to initially construction, I approached the civil court, I was in the interior.
This MFA is arising out of an IA in the same proceedings? or
Both
different?
some IA in the same proceeding. Against the 39(1) and 2.
ಅಲ್ಲ ಅರಮನೆ ಆಲೆ ಕಟ್ಬಿಟ್ಟಿದಾರ ಇಲ್ಲ ಗೊತ್ತಿಲ್ವಲ್ಲ.
ಇಲ್ಲ ಅವ್ರು ಈಗ ಇನಿಷಿಯಲಿ ನಾವು ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಡಿಸ್ಮಿಸಲ್ ಪೇಜ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಮೊದಲು ವೆಕೆಂಟ್ ಸೈಟ್ ಇತ್ತು. ಅವ್ರಿಗೆ ಕಂಪೌಂಡ್ ಹೊಡೆದು ಕಟ್ಟೋದಕ್ಕೆ ಟ್ರೈ ಮಾಡಿದಾಗ ದೆನ್ ವಿ
The appellant submits that the defendants had relied upon a rectification deed
of 2019.
Of 2019, which was taken note of by the trial court without appreciating the contentions of the plaintiff who had relied upon the
Mars, I have relied upon exhibit P2, which is the plan approved by the town planning
P2
authority.
house. It is further submitted that during the proceedings before the trial court, injunction granted against the defendant was upheld by order in MFA 200516 of 2023. And such order continued till the judgment was passed.
House.
Next, further submitted that after dismissal of the suit, the defendant is making attempts to put up construction. Taking note of the order in MFA 200516 of 2023, which would prima facie indicate the 200516 of 2023, which was in operation till the judgment was passed. Subject to further consideration, parties to maintain status quo as on date till the next date. Emergent notice to the respondent, TCR to be summoned forthwith.
Since it's first appeal, my lords, it was admitted and.
Let us see on the IA, they may come and then.
For appellant, my lords.
Madam, I am for claimant.
Last day to lordship directed to give calculation, submitted calculation, my lords, quantum, my lords. Bachelor death, my lords, and
We have
50%.
filed a calculation memo calculation, last date of hearing. Last date of hearing, we have filed a memo of calculation. Madam.
You also filed memo of calculation.
Yes,
I have also
yes,
filed, my lord, because,
Clear the matter.
my lords.
Then we have to hear the matter.
Yes, my lord, because merits of the case is that my lord is a bachelor, my lord. They are wrongly deducted.
Date I can actually we'll hear the matter.
Please, madam. Yes.
Not by consent alone, memo.
No, ma'am.
Then we have to hear alone.
Yes,
Next you can.
yes.
Your Lordship, serial number 46 kindly have it up.
No date. We'll relist it, please.
Court officer.
Madam, 40 date.
24th date.
40 date. What is the
Sir, serial number 46, serial 24th, 24/2. ಕೇಳ್ತಾ ಇದ್ದೇನೆ ಸರ್.
Madam, 40 and date ಕೊಟ್ಟಿದ್ದೀರಾ?
47 court officer 46 ಯಾವ ಡೇಟ್ಗೆ ಹೋಯ್ತು?
ಸರ್ 24th ಸರ್, February 24th.